Gary Harrison, the man, Gary himself. Oh, Gary Scary Larry. Anyways, he's the stamp guy. He's the one that stamps. He's the official stamp guy, right? So it says, whereas incumbent clerk of Superior Court Gary L. Harrison has retired midterm. Odd timing. Mr. Harrison's effective date of retirement is March 31st, 2025, and whereas on March 31st, 2025, the governor of Arizona appointed James W. as clerk of Superior Court effective April 1st, 2025, and whereas there must be a continuation of the operation of the business of the clerk of the Superior Court in Pima County, now therefore it is hereby ordered the file stamps, signature stamps, certification stamps, signatory authority, and official documents bearing Gary L. Harrison's name shall continue as the office name of the clerk of the Superior Court in Pima County until modified by the clerk of the Superior Court appointee James W. whoever. Word. But guess what? How long has he been? That's just his effective retirement date. How long has he been gone? How long have they been stamping their own stuff? Anyways, I want to address this guy's comment. Anyway, I want to talk about this guy's comment real quick, and then we'll jump right back into it. I just want you to let that stamp thing marinate. To kind of introduce myself, because y'all don't know who I am, and like Forrest Gump style. Now we ain't strangers no mo. But no, he said, you sound as if you're jealous of the adulation going Lane's way. Would you like to speak about your accomplishments and see if anyone here will throw you a good job your way? Okay, I am going to speak about my accomplishments, but my ambitions are zero. I am not an ambitious person. I never was. I had everything I wanted. Well, I thought I wanted by the time I was 18. But anyways, that is my real name, Jason Zawak. That's my real name. I live in South Texas. And I would not like to speak about my accomplishments. I mean, good thing they're all on video camera. So, here's what I used to do for a living. Oh, scratch that. I have a better idea. I'm going to tell you what I used to do for a living, and then you formulate a picture in your head of what that looks like, and then I'm going to show you, because whenever you see it, I guarantee it's not going to be what you had thought, the picture you had in your head. Guaranteed. But do me a favor and come up with something more clever than good job. Please. Guaranteed. I was a professional rollerblader. Okay? And now, just mind you, I downplay shit a lot. So I'm not really going to talk that one up, but just picture that, what you think that looks like in your head, okay?
So the blood all over mirror. It might have been all over if you were to barely crush, but you got greedy, pumping too deep, and now she's scared of trust, but can it trust anyway? Every opinion stated by an experience, making thought a response to memory. I am my enemy, can't pick my way out of this penitentiary. Embracing condition, humanity's mechanically accepted for centuries. It's the water, is it real? How does it make you feel? Being endlessly dependent on external crutches and shields. Sleepwalking through the dust covered fields, haunted by the taunted souls of those who kept the shield closed. I've stretched the distance and pushed the envelope. This song's become an endless note for all women and men with hope. Open your eyes, you no longer can float. You're sinking and drinking the powdered water gon' make you choke.
This is the end of my street. Well, it's like the beginning too, I guess, technically. Texas, South Texas. Here are some deer that were in my front yard one night when I came home. It was pretty crazy. What are you doing in my yard? Yep, you. What are you doing? Huh? What you doing? Ruff, ruff, ruff. Better get the fuck out of there. All right, starting from the top.
Going to make a mistake trying to hold me in contempt. You're going to find out.
Pay attention to how thick his glasses are, and when he gets close to the phone, how the glasses go down, and he looks like up above them because he can see up close, but far away he can't. He promises not to cuss, then she tells him to have a seat, and then he sits down, and then she says, "Show your face," which is already showing.
Don't give me your speech. Have the court date just like we're going to have it. I'll act normal. I won't cuss. If you don't like cussing, if it hurts your feelings, I won't do it.
Mr. Mills, have a seat, please.
I am seated.
No, you are not.
What's that?
Have a seat.
I am seated.
You are not.
I'm
You're
sick.
standing. You're very clearly standing.
I'm sitting on a bar stool. You don't know what you're talking.
Mr. Mills,
You're telling me I'm not. Are you really?
you are yelling at a judge, and I recommend you stop it right this second.
Do you want me to sit on the floor?
I want you to show your face in court.
Oh, my face is right here. See it? Look at that beautiful face.
Okay, now it's my turn.
Even though his face was right there the whole time, she's just having a one-sided conversation. This is what they do, man. When they start telling you to sit down and every sentence starts with your first name, it's so they can make the record later and make it sound like you are just, you know what I mean? If they start every sentence with Mr. and then your name, and they start telling you to do things, that means they're trying to attack your conduct or use your conduct to cover up what they did or to use it against you somehow. It's all courts do it.
To talk. I have received multiple evidence from you.
What is it? What have you received? It was kind of like broken up when you said it.
Mr. Myers, I have received multiple filings from you.
Yes.
So here's the deal. These filings all include profanity, threats, and insults.
How does that make you feel?
No, Mr. Myers, I am speaking right now.
Okay.
Remember, she said
my case was
profanity,
going to
threats, and
fucking- was being
insults.
transferred, and one was staying. I filed an objection right here to that transferring that shit. Let's see. Let's find some. You would think this shit was full of fucking profanity up and down, right? Let's see. And everybody can like watch this later. I'm not gonna sit here and read all this, but you can see I'm scanning through. I'm looking for a cuss word. I did say they've embarrassed themselves. They're violating my rights. I'll leave a trail of disbarred judges. Filing a motion to dismiss. Should not even need to. This is kangaroo bullshit. Oh, okay. Bullshit. Okay. Okay. So in this entire, now I don't think it's profanity, and profanity, one man's music is one man's lyric is another man's, like, you know what I mean? Profanity and shit. So like this shit, all right. So, but what, like, now remember, I got to be careful because I'm not going to say that my own stuff is profanity, but there's, you know, the nurse, the 80-year-old lady at the nunnery would go through this. Now, was there strong language saying, You're violating my rights. Must be held accountable. Did not waive his right. I object.
Ask you to lay some foundation as to witnesses who are going to be available at further proceedings in this trial before you go forward with that, however.
Yes. So, Detective, for this information that you gathered, how did you gather this information?
There were
What he just said. I want to put an objection on the record to the first thing he just said. He said that I was releasing body cams and body cam and body worn camera and police reports that they provided. That's wrong. I got it from a public record request from Chris Avey, city attorney. So anything I get from a public record request, I can put on my YouTube channel. Now it might be the same material that's in their disclosure, but we could go to court. Charge me with contempt. I'll show you the public record request. You can see a video on my YouTube of me giving the public record request to Chris Avey, and Chris Avey going, here, take a picture of me. Chris Avey stands on my thing and goes, look, I got your public record request. So he's lying again. He's lying. He's lying. He just said I should be held in contempt for releasing a public record received under a public records request. He's lying. He's attempting to manipulate because I sound crazy and all that. He's trying to be the voice of reason. He's the voice of lies.
Number one.
He gets to tell you what you need to do.
I'm requesting to modify Mr. Myers' conditions of release accordingly. Number two, Mr. Myers needs to be directed not to have any direct contact with judges, court staff, city prosecutor staff, or other city employees. If he wants to do something on a case, he can file a motion through the appropriate
He just
channels.
asked you, objection. Objection, public officials. I can contact public officials at any time. Every person he just said is a public employee. You will not take away my rights.
And these are people that Mr. Myers has been harassing and calling cunts, among other things, Your Honor.
Objection, irrelevant, man. What the fuck does that got to do with what I did on May 20th? Who I called a cunt? He's tainted. That's irrelevant. You're allowing him to prejudice the jury, sir. You're supposed to be impartial. That means that if the jury was sitting here, you wouldn't allow him to say that I called a public employee a cunt. That has nothing to do with this case. So you have to act the same as if the jury was sitting there, sir. That's how you have to be at all times, an impartial jury.
Let me ask you this question. How do I know what he's going to say to his testimony?
Who? Ahead of time. Ahead of time.
How would I know ahead of time?
Ahead of time what he's going to say.
How would I know ahead of time he's going to say what he's going to say?
But now that he said it, why didn't you say that's irrelevant? Why didn't you say that has nothing to do with his guilt or innocence on May 20th? Then why the fuck? That's the third case courtroom I've been in where he talked about me calling him cunts. Hey, cunt is free speech. Whatever. So,
But it's not polite speech.
I don't care if it's polite.
In this courtroom, you be acting.
I understand. Don't call nobody in here. But I'm saying, he's saying that in my communications with public officials, I've called them that, right? That word, right? Mm-hmm. That's my right.
Okay, so Riojas denied all of Matt Walker's everything, and then granted Lane an opportunity to interview the cop and to compel Matt Walker to disclose the witness list, and also didn't give him any conditions of release or modify or whatever the hell he was asking for. So 3-0 Lane. Oh, and then so Matt goes home, shitbag, fucking. Schmuckwad Matt Walker goes home and drafts a motion for Lane to have his mental sanity checked or whatever, his competency. And in that competency one, in that motion, this is where he expresses his that Jordy Perez and Mackenzie O'Brien are victims, and they attempted to help the defendant find his part and blah, 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 which they didn't. But yeah, victims. They're the victims. Remember that. Mackenzie O'Brien's a victim today on whatever it is, September 18th or whatever. It declares Matt the schmuckwad.
I won't use that. I got it. Hey, no, he let her handcuff her. She got she got to read the police department laptop. Watch the video, sir. Watch the video. I'm not taking it down either. The whole world needs to see what happened to this. The whole world needs to see what happened. She asked the cop to arrest her. They sat there for 45 minutes. The cop said he could beat her. No, dude, there's no trial. You're about to dismiss this case. Okay, well, there won't be no trial with you then.
My turn, Your Honor.
To lie.
Back to what I was saying. Under 15.4D, none of this material is supposed to be disseminated.
He's talking about the police report and a body cam. See how he's saying material? Police reports and body cam. Police reports and body cam.
Common courtesy.
Police reports.
I'll let him interrupt
Thank you. Thank
And
you.
you will not interrupt him.
Thank you.
Go on.
Material that's provided under Rule 15, like the body-worn camera and the police reports, is not to be made public. So on that basis, Mr. Myers has violated Rule 15. The videos need to be removed from YouTube, number one.
They're not coming down.
Number two,
Ever.
if they don't come down, the state is going to ask the court that you hold him in contempt.
And I'll do it. Pay, how much do I owe? The videos are not coming down, sir, ever.
Second thing is...
It's my First Amendment right. And no, hold on. Objection. I know. Let me peacefully. All right.
As far as the interviews of the officers, Your Honor, the state was prepared to set those until Mr. Myers' conduct made that impractical. The state thinks that what would probably be best is if we simply have an evidentiary hearing where we can do this under oath in a court. Mr. Myers can essentially take their testimony, it'll be sworn testimony, which is probably more effective anyway. Is requesting that Mr. Myers, actually he has, Your Honor, but that's fine.
The record. I know I can't contact the victim. He just accused me of contacting the victim, so put it.
And what is Mr. Myers in jail for right now? Contacting a victim. This is the only game they have, dude. And they've tried it on him 3 times. This is like him being in jail right now is the 4th time they've tried to do this to him. It's just that they keep him. Anyways, he knows not to contact the victim.
Put it on the record. He explore it further. You can't allow me to contact the victim either. So if he just said I contact the victim, put it on the record. I know I can't contact the victim. He just accused me of contacting the victim, so put it on the record. He just said it, sir. The whole world can hear him say, actually, he did contact the victim. So now he needs to articulate how I contacted the victim for the record so that the only thing that's not on the record is, actually, he did, sir. He needs to articulate his position like a lawyer. He just accused me of contacting the victim, sir. That's a violation, right? If I contact the victim, that'd be a problem, wouldn't it?
If he decides to charge you for that.
If who decides to charge me? He doesn't get to decide shit about contacting the victim. He's asking you about me contacting the victim. If I...
I was asking these to tell you not to contact.
No, he's saying that actually I already did. He just accused me of contacting the victim. Your reference on the record, just like an evidentiary hearing, all that shit. I have the right. You have just like he's asking you to. You need to order him to articulate how I contacted the victim if he's going to make those allegations into this microphone.
You can request to make it, but I don't have to follow your request.
You're saying I can request that you make him articulate it, and you're saying that's something we decide. That's like an objection in the moment or something. All right. Well. Hey. So objection on the record.
So I'll be recorded, it's on the record.
Oh, it's being broadcast live.
That's fine. Okay, so you're suggesting an evidentiary hearing as opposed to
witness interviews.
Take up the court's time. Take up the court's time because grown-ass men can't have an interview. You fucking arrested me and held me back in the cop car for an hour and a half and said a jury's just 12 people too dumb to get out of jury duty. Don't give me this he's scared shit. I'll go to the police station. If it's criminal contempt and you want to try fine over $300, criminal contempt doesn't carry jail. It's a civil infraction. It's not a crime. You can't be taken to jail for contempt. You can be detained while a show cause order is issued. You are not going to weaponize the court either, sir. He's not gonna.
Little does he know, Judge Ball is sitting in the corner in the dark, smiling, laughing, saying, "Ha ha ha! Challenge accepted, bitch. Wait till you get in my courtroom." Okay, now, so this is September 18th. 4 days before this, on the 12th, is when Shannon claims that their relationship started or whatever, nothing. She claims that nothing happened, but that was just the one voicemail on the 912 that he left for Matt Walker, not for her, but for Matt Walker. See, Lane Myers is a defendant in a Tucson City court case that my spouse, Matt Walker, is prosecuting. On this day, Lane Myers called me at work and left me a voicemail asking for my assistance. Again, a valid reason. And this is the only communication that they've had. And they haven't even met yet, right? He doesn't even know what she looks like or anything. Anyways, okay, so and this isn't her petition for the injunction for harassment, which the one we're about to listen to, because she got it ex parte with Matt Walker, her husband, the prosecutor, sitting behind her, listening and coaching the whole time.
also their use of electronic communication to intimidate and to threaten. So I will be making those findings. Now, with those findings, I do want you to understand, and I'm sure you do, these are not criminal findings. I'm not making that he's not being charged with anything. These aren't criminal charges. These are findings I'm making to provide you with a civil injunction. And so it is, again, only a piece of paper, though.
Of course.
So you're aware that these can sometimes incite as much as they can bring people down, but it will protect you from any third-party contact as well as indirect contact from him. You also understand the concerns about trying to get anybody to not post things on the internet or YouTube or stuff. We do have some overlays with the First Amendment there that we're not sure how far. I'm not sure how far this is going to get you, but
Right.
or as far as protecting or stopping that, but it should be strong enough to get those third parties who are his followers or whatever they may be called. Ideally, they will understand that they're included in some way on this. I'm probably going to have to be told, but
Yes.
get the general idea. So based on the pleadings, the court finds reasonable cause to believe the defendant has harassed it by committing one or more acts of harassment, and therefore it's ordered granting the injunction against harassment and orders that the defendant will have no contact with the plaintiff, with the protected persons listed in the injunction against harassment, or with the protected locations. The court further orders regarding this order of protection. A constable will not serve this for you. So it will go into effect when he is served, but you are going to need to personally have that served on him, either hire a process server, take it through the sheriff, whichever you fit. Obviously, you're not going to hand it to him yourself.
Right.
But, you know, it's important, and I'm not telling you anything you don't know. If he violates this, you must call the police. It is only as good as you are in enforcing it. And if you want this to truly protect you, be sure to take advantage. The court's not an enforcement mechanism. It's the police that will enforce this, but do not hesitate to call them if he violates this in any way. Okay?
One question that I do
Please
have
do.
is regarding the videos that currently exist, as well as additional videos, which I do think you are correct. This will likely incite more of a reaction. Does this injunction against harassment provide any sort of protection for additional videos or any sort of enforcement for him to take down the current ones?
That would be up to a prosecutor. I'm really not sure how they would interpret that. I think the ones that are already posted, I think you're going to have a hard time getting those down just because of the nature of the internet. I think, though, that if that is something that you should probably pursue with the prosecutor's office or through a police report if you want to try to do something with that. That would be my advice.
Okay, thank you.
I'm not sure how far this is going to get you from stopping those, but if you don't call the police and try, it's not going to get you anywhere.
Right. Okay. And I guess that's my primary concern is not just him, but the harassment that he is inciting through those. So.
And, you know, I think those could possibly be seen as third party contact, et cetera, et cetera. And I think that's going to depend on how the prosecutor's office wants to interpret that.
Understood. Thank you.
Okay. Do you have any more questions for me today? Is there anything else I can do for you today?
Sorry, I just want to ask a question. Can you just ask specifically about future videos if that's inconvenient?
Your Honor, does this order, injunction against harassment does it encompass any future videos?
It should.
That's what Matt Walker had to sit in on this ex parte conversation to ask about. You know how retarded it is to ask about future videos? Okay, let me break it down for you. Think about this. A sign when you walk into a restaurant that says free beer tomorrow. Think about it. You walk in tomorrow and the sign's going to say free beer tomorrow. Ordering somebody to take down future videos, every time when he looks at the order, it says, okay, no future videos, and then makes the video and it becomes present day, and he's going to look at the order again and say no future videos. It does nothing. It is nothing. It means nothing. This guy is an absolute retard.
I mean, you know, especially if a video is like directed directly at you, I think it becomes a little questionable. If it's a general, generic, you know, that's really going to come down to interpretation.
Okay.
Does that help at all? I wish I could offer more than that.
No, we very much appreciate, Your Honor. Thank you.
Okay.
I think that's all.
We'll go ahead and we'll get this in place. You will go back to room 203. They'll get you all the information. It should be through to you shortly, okay?
Thank you very much.
I wish you the best, both of you.
She goes back the next day to Judge Walton, the very next day to a Judge Walton, and which they pulled a bunch of strings to get Judge Walton in there. And then it's a whole different conversation. It's not even a conversation. She just accepts the fact that the injunction is there and then just modifies the conditions and says, at the very end says, well, they can tell me if I'm not supposed to do that. Ha 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 ha. And they start laughing and shit. I just don't have time to show it, but it's on his page. All right. So then after that, after Walton,
Interrupt me again, I'm going to ask you to leave.
I'm about to leave voluntarily.
You're not going to get a chance to make your record.
You're getting overturned on appeal whether I do or not.
So you've been warned.
You've been warned. You're getting sued too.
All right. I'm asking you to leave.
Thank you.
Thank you.
So that'll be posted on. Somebody will mail it to me or something.
We're going to give it to you right now.
Cool,
Just
thank
sign
you.
right here for me saying that you got it. Sign this right here saying that you got
Right
it.
here? Cool. You guys can talk amongst yourselves.
Do you want your little flash drive back?
Yeah. I thought it was on the record for appeal.
Hold on, let me check. Maybe I misunderstood. Oh,
yeah, that's not under duress or
Why is my
anything.
exhibit not being turned in for the appeal? That's what we turned exhibits in for the record for appeal.
You've lost your chance to be here. You keep interrupting me.
That doesn't mean I lost my chance to put an exhibit on the record.
If you want to go outside
Just
and
sign
come
this
back
right
in
here.
5 minutes after you calm down and follow the rules, I'll let you. But right now, you're not following the rules. You need to leave.
it's your choice.
Should you want me to leave my stuff here?
You want to come back in 5 minutes?
That needs to be, yeah, sure.
All right, go outside.
Turn
calm
off
down.
your.
I don't need to turn off my recording.
Yeah, it has to be on your person.
Then I'm not, then I'm just leaving.
Turn off your recording. No, I don't have to turn off my recording. It has to be on your person. I'm just leaving then. What am I signing? Those are not the four sentences you want to hear at the end of any courtroom hearing. And that's the active injunction, the one they say is active right now.
Asking us to investigate harassment charges and...
Did you hear that? Investigate charges. You don't investigate charges. You investigate and then you can charge somebody.
later on, violations of an injunction against harassment that she had filed against Mr. Myers.
He said she, so I'm assuming that's Shannon Walker. But let's check that out. Let's see the injunction she filed.
And have you spoken with the victim?
I have.
And are you aware of whether she will be available to testify at trial?
She will be. Mr. Myers. Investigate harassment charges and later on violations of an injunction against harassment that she...
Now, the information that you were gathering, was that just from Ms. Walker or were you gathering it from other sources?
So I was gathering it from Ms. Walker, but I was also gathering it from Mr. Myers' YouTube channel.
So you and the victim are sitting around all day watching YouTube videos, getting paid to sit around all day and watch YouTube videos. Okay. And then you're going to use it as evidence against him.
That he is active on, I wouldn't say on a daily basis, but he's very active on it. So obtaining videos through his YouTube page and through other YouTube pages that associate with his page.
Correct me if I'm wrong, but isn't that exactly why Mr. Myers is sitting there in the defendant's chair in the orange jumpsuit? Pages don't associate with each other. People associate with each other, and they're not pages, they're channels. So I, Eric Brown, have a severe lack of understanding of what the internet thingy is.
Were you also in contact with Matthew Walker?
I was, yes.
Okay. Was he providing information to you about what was going on?
He did also provide information in relation to Shannon being contacted due to his work with a case that would involve Mr. Myers over at Tucson.
So the victim's unethical prosecutor husband is standing behind her again, and also now is adding to the evidence that all the stuff from his case, his legit case, that Mr. Myers has a legit reason to contact him, all those communications are now being used against him. Okay, so the cop has just told us that the unethical loser, Matt Walker, is giving him evidence too, and probably from his job as a prosecutor prosecuting Lane Myers. And he sits in the back seat of all of Lane Myers' hearings. So, I mean,
speaking
who's to
with
say he's
him,
not using,
are you aware of whether
just
he
stalking
will be
him?
available to testify at trial?
He's literally
He will be
stalking
available
him.
as well.
Oh, well, thank God. I thought it was going to be unfair or something like that. You're telling me that the victim witness and the primary evidence gatherer, right, her husband, the prosecutor, who was recently just prosecuting Lane Myers, the defendant in jail right now, sitting there in a jumpsuit, those two are going to be the ones that all 100% of the evidence is given by them. They're the only two witnesses to anything that, if there is anything, and they're going to be the only two testifying.
So now you reference that Mr. Myers has a YouTube channel. How do you know that that's Mr. Myers' YouTube channel?
Because you can clearly see him on the YouTube channel. He appears physically. He often says his name. So it's clearly him.
Can you lay some more foundation, or just can you stop being retarded and making retarded statements like that?
So in relation to what Mr. Myers was doing with Miss Walker, when did that approximately start?
It approximately started September, October of 2024.
And then how often has this been going on?
So it's still currently going to this date. The harassment that she felt was up to the point where she obtained the injunction against harassment in October of 2024. That injunction was then modified in November of 2024, and it is still active today. And she still is receiving things that are harassing in nature to this date.
Okay, we're up to present day. Now, I'm gonna give you a visual, because in my head I see it, but when I write it out, it looks different. So maybe it'll help you guys. Okay, on the left is all Mr. Myers' judges up until now, and then in the middle is all Matt Walker's appearances in, well, the courtroom or the case, and then Shannon Walker's, right? But see, Matt Walker, his prosecuting ends right here at Riojas. Woohoo!
It approximately started September, October of 2024.
So prior to getting those injunctions, can you just give a brief description of what type of behavior was happening that led to the injunction?
So she was receiving phone calls from third parties. Mr. Meyer went on his page and he was encouraging his followers to reach out and contact Miss Walker in relation to the conduct of her husband, to just let her know that he was corrupt. And
so what's the difference between now and whenever they first told him about the phone call? Now he can't defend himself. He can't say anything. It's a bond hearing. This is ridiculous, dude.
Just were generally not good people, which led to her email and phone number being flooded with harassing emails and phone calls.
All right, I read 122H. Are you familiar with 122H?
I am not. I would like to respond.
It does permit the use of a personal audio recording.
So I point you to Arizona Rules of Protective Order Procedure 8A2, which requires a judge to ensure that the parties are treated with fairness, respect, and dignity and are free from intimidation, harassment, or abuse during the court process.
The victim is to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal process. And just from him getting a summons, he immediately...
Rules of Protective Order Procedure 8A2, which requires a judge to ensure that the parties are treated with fairness, respect, and dignity and are free from intimidation, harassment, or abuse during the court process. In addition, Arizona Rule of Protective Order 38E says that the court must take reasonable measures to ensure the parties and any witnesses of the hearing are not subject to harassment or intimidation in the courthouse or on adjoining property. Mr. Myers has live streamed previous court recordings.
This lady's a law professor. She literally just reads books all day about law, and she can't tell the difference between a protective order and an injunction for harassment. Give me a fucking break. And this is in between, where he's at now and where he was with the injunctions. Like, they did this to him on the side, just trying to get her to do this. And she's literally reading from a script.
Adjoining property. Mr. Myers has live streamed previous court recordings and posted videos about me and discussing me on his YouTube channel.
Objection, Your Honor, that's not relevant to the complaint.
Let her finish.
She's going outside the bounds of the complaint. She's talking to things that are not in the petition. This is not a protective order. This is an injunction for harassment. Those rules do not apply. 122H applies. I was just at an injunction for harassment hearing.
Sir, would you let me listen to her first, and then you will have the opportunity to speak?
The videos posted by Mr. Myers have also prompted other videos on YouTube about me and
Sir,
have
she's
prompted
litigating
people.
the case. She's litigating the case right now, sir. You cannot allow yourself to be prejudiced by you.
Sir,
this shouldn't even be happening right now. This argument about 122H shouldn't even be happening, and you're allowing her to make arguments about a protective order, and she's pulling out legal jargon that is not applicable here, and she's talking about videos that are not in the petition. They're not in the petition. She's prejudicing my fair trial right now, and you're allowing it. This is all on the record for appeal. The transcript will show you're allowing her to talk about a protective order at an injunction for harassment hearing. Follow the rules. This is a civil procedure. It's not a protective order.
I'm not finished.
So how does a protective order help their cause or whatever? Why does she keep trying to push a protective order when it's an injunction against harassment? She's a law professor. She's not that stupid. She knows the difference. Well, the reason is because they are relieved of their responsibilities if there's one out on the... They are the defense in the connection with sentencing, disclosure, the defense, and the unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order. So literally all the mistakes made with disclosure and all the bullshit they've been withholding will be absolved, and they'll be relieved of their responsibility if there's a protective order. So they got her to...
And how do you recommend?
All right, remember the very beginning of the video, the stamp thing?
And from your knowledge of the case,
she had the cop read his arraignment documents into the record, which I thought was weird. And then she says this.
These documents are also, in Your Honor, these documents are also stamped and signed, so they're also self-authenticating. So stamped and signed, so they're also self-authenticating. So stamped and signed, so they're also self-authenticating.
I think she's giving a whole new definition to the word self-authenticating, because when you own the stamp of approval and you can literally stamp your own work,
Any objection, Mr. Parvin?
No objection.
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 We'll show 3, 4, and 5 are admitted. Thank you.
What type of conduct was prohibited in the injunction?
The injunction.
You tell me if that
Mr.
shit is
Myers
fair.
from contacting the
Fair
victim at
trial,
all,
integrity
and
of the
it also,
investigation, integrity of the courts.
prohibited him
There's no
from,
fucking integrity. These guys are
posting
fucking
or
animals.
displaying the victim's
Free Lane Myers.
contact information, which would include her work information on any social media platform. He was also prohibited from having any direct or indirect contact with Ms. Walker.
Have there been issues with Mr. Myers posting videos and people?
He's continued to post her work information to include her phone number and email, to which then she's been getting harassing phone calls and emails pretty much on a daily basis from that time.
Has there been evidence that you've seen that indicated that Mr. Myers knew that his followers on YouTube were contacting the victim?
He has spoken about it on his YouTube channel, yes.
Now, are you aware of charges currently pending for Mr. Myers?
Yes, there are current charges pending.
And how are you aware of those?
I was a detective that investigated that case.
Wait a minute, you investigated a case? You just said you were sitting around just watching YouTube with Shannon all day. When did you investigate? What did you investigate? All you did was just collect emails, which doesn't even take any work.
Your Honor, may I approach the state 6 through 10?
Yes.
Would you please take a look at those?
Yes, number 6 is an indictment with Lane Jeffrey Myers listed as the defendant with the counts that he was charged with in that court case. I can read them if you prefer.
Yeah, that's okay. Can you go, and then what's the next document?
So Exhibit 7 looks like the arraignment order and appointment of attorney for Lane Myers. And number 8 is the court paperwork for the initial appearance and arraignment, the minute entries from that court date.
And then for the arraignment date, what date was that?
It looks like it was on April 15th of 2025 at 9 a.m.
That hasn't even happened.
Or no, that's
This dude's reading these documents into the record. He doesn't even know how to fucking read or follow one, dude. This is absolutely retarded.
The judge signed it on March.
Since you guys made it to the bonus time, this is just bonus, all right? All right, do me a favor.
Yes.
Look up what an arraignment is. There's literally one purpose of an arraignment, and that is to clearly make the person that's being charged aware of what he's charged
Again,
with.
what is the date
That's
on that
the
one?
only purpose. Listen to Lane Myers' arraignment.
Also March 14th,
She talks for over 12 minutes and does not accuse him of anything. She does. Well, she accuses him of a bunch of shit. She even says he's guilty of crimes, but she never says what they are. Think about that. That is so telling. That right there should tell you. And then he accidentally, or then he breaks the conditions of bond.
Yes.
Well, if he doesn't even know what he's charged with, literally go listen to it. In fact, I'll put it up for the next video.
The minute entries from that initial appearance.
Mr.
And have you had a chance to review those videos?
I have, yes.
Oh, I thought you'd never ask, because I have reviewed one. And oh my God, it is more G-rated than you think. Okay, so the arraignment and the video will be the next videos.
A police report said something about Shannon being an ex.
Okay, I know some of you guys aren't as sonically sound and focused, but they are good friends. The way she said her name right there, they are good friends. I'm telling you. It's not just because she used her first name. I've heard her use her first name before. But the way she said it right there, she said it with some conviction. They are good friends. Oh, my bad. The whole point for this was to show you that the little detail about the X or whatever, the cop didn't accidentally put that in there. He put that in there on purpose, right? He wrote it out. And the reason they did that is because one of the reasons you need for a protective order is you need to have a relationship, a close relationship, like an ex-girlfriend or something, with the person so they can get the protective order. So unless they had a relationship, they wouldn't be able to get this fake protective order that they tried to, just sneak in there on him. So anyway, that just proves that.
Was Miss Walker's ex, which is not true. But I'm just not sure how that part got into the report. It just was a typo by the officer.
And so was that was discussed in that video?
Yes.
Okay. And the clip that for that video, the slapping style sanction clip that for that video, the slapping style sanction clip that you watched prior to this hearing for the slapping style sanctions, what is that clip showing?
It showed was Miss Walker's ex, which is not true. But I'm just not sure how that part got into the report. It just was a typo by the officer.
Okay. And so was that was discussed in that video?
Yes.
Okay. And the clip that for that video, the slapping style sanction clip that for that video, the slapping style sanction clip that you watched prior to this hearing for the slapping style sanctions, what is that clip showing?
It shows just a portion of that video where it shows the injunction being displayed and the victim's work information being displayed on that video.
And I think, Ms. Stiles, you'd indicated that states 12 you don't intend to play, but it's actually the entirety as opposed to a clip. Is that right?
That's correct, Your Honor.
All right, Mr. Parvin.
Yeah, so the state's intending to play a clip because I have some concerns here about whether any information was shown, at least on one of these videos.
Yes. And Your Honor, just for the purposes of this, I'm going to ask just to be able to play it for the court without putting it up on the screen because we are showing information for the victim.
Really? You're going to play it for the court, but secretly, but you're not going to play the whole video, just a part of it for the court, secretly, in court? Fuck you.
Was shown. So that's, as long as I can see it too, I'm fine with that. So I can make arguments.
All right. So I am going to show over defense's objection that states 11